Good morning and welcome to Cornell Cooperative Extension's monthly Consumer Issues broadcast. I'm Kenneth McLaurin, the financial educator here at Cornell Cooperative Extension of Tompkins County. Today's topic is home improvement scams. We have Michael Danaher with us today, the New York State Assistant Attorney General, here to discuss this topic with you. Over to you, Michael.
Thank you, Kenneth. Welcome to everyone here at Cornell Cooperative Extension, those of you joining us out in TV land as well. This is an important topic that we frequently receive complaints about in the Attorney General's office, which is home improvement scams or problems with home improvement contractors. Our homes are probably the largest investment that we make throughout our lives, and we want to keep that investment up, so we frequently have to have people come in and do work to repair. I can use my own personal example. We just, within the last day or so, had to have repairs done to our electrical system in my house. I've lived there for over 25 years, and the house was built probably 30 or 40 years before that, and things break, and things need to be done. And I've had to put new roofs on my house. I've had to put in new electrical system and all types of things. So we seem to have a new project every year, and a lot of people do have new projects every year. And so we want to be good consumers and make sure that the person that we hire, the company that we hire, provides us with the services that we expect to receive and that they are good, and that we can be assured that the money we're spending, which can be quite significant, is the best that we can do for our particular problem. So there's certain things that we can do to be good consumers when we're considering going into a home improvement contract. One is know exactly what work that you want to have done. Make sure that you're specific about what you need to have done. Make sure you understand before you engage the home improvement contractor what it is that you want done, and make sure that the home improvement contractor understands what you want done. And the important thing is don't be talked into something that you don't necessarily want, and more importantly, don't necessarily need. So going into the project ahead of time, decide what you need to have done, and then you can work from there. That's the best way to start. Another thing is that in some instances we need to have permits for work that are done on our house. You need to check with your own municipal code enforcement officer and code enforcement office to see what it is needs permits and what doesn't need permits. For example, maybe your roof repair or replacement doesn't need to have any type of a permit done. But if you're dealing with electric, or you're dealing with plumbing, or you're dealing with adding to the structure itself, you may in fact need to have a permit. The important thing is to find out if you need one and what steps need to be taken. As a matter of fact, you also need to check with your contractor as a part of the deal to find out who is getting the permit. The worst thing that can happen to you is have work done that needs a permit. You think the contractor is going to get the permit for you. Contractor thinks you're going to get the permit. All of a sudden, nobody gets the permit, and then you run into trouble with your local code enforcement office. So check with the local building code office before the project begins to see if one is needed. And if one is needed, are there inspections that need to be made along the way, and make sure you understand who's going to do those inspections and who's going to arrange for those inspections. Next thing is shop around. Look for multiple contractors, get estimates from them, get quoted prices, find out what the proposed timeline is for the contract. Another thing is very important, get references and check them. Find out where else they may have had work done and check with the people. Check and see if they're pleased with the whole way that their contract went down. Make sure that the person is a reputable contractor. If you want to make sure that they have insurance, there are different insurances that are related to it. So don't just ask the contractor, do you have insurance? And the contractor says, yeah, sure, I have insurance. Well, what type of insurance do you have? Some people don't realize that there are multiple insurances, and the insurance that you think they may be having, they don't have. For example, if they have workers, they must have workers' compensation insurance to protect their workers in case the workers are injured. Make sure they have that if they have workers. Or if they say, oh, I don't need it, you look into it to make sure that they don't need it. In some instances, they may say, well, all of the people that work for me are independent contractors, so they should have their own, the workers themselves should have their own insurance. That may not be the case. You may want to check with the Department of Labor to see if, in fact, the person is hiring people that should be covered by a workers' compensation insurance policy, or whether or not they truly are independent contractors. Also, you want to check and see if they have insurance for your particular job. It may be liability insurance, meaning if they do something that causes somebody to be injured as a result of the job, do they have coverage for that? And that coverage is separate from coverage for you in case they don't finish the job or they don't do the job properly. If you want to make sure they have that particular insurance, they need to have a particular insurance policy that says that you're covered. It's in essence a bond. It's a bond to ensure that if they don't complete the job, that there will be insurance protection so that you can hire someone else to finish the job. Many contractors do not have that, so you want to check and see what the circumstances are. That also falls back to what we originally talked about, is make sure you get a reputable contractor so that you don't even have that problem to begin with. But I just throw that out there. And get proof of the insurance. Don't just rely on if the person comes to you and says, yeah, I have insurance. You want to see it. On a liability policy, they can actually name the homeowner as an additional insured under their policy, so that somebody gets hurt because there's a construction project going on at your house. Somebody is walking by and they fall in a hole because there's going to be a new basement put in or something. They will sue you as the homeowner, and you should have your own insurance policy. That's a given. You should have. But you may also be named as an additional insured. In other words, another covered person under the contractor's liability policy. You can check and see if that's the case. It doesn't take much to have you named as an additional insured under that policy. It doesn't cost them any more money because they're protecting themselves to begin with. So then they can protect you for the work that they do. So another word of advice. In some municipalities, not any in upstate New York, but in downstate, Long Island, New York City, and maybe Westchester County, home improvement contractors actually have to be licensed. They don't have to be licensed up here. Up here, they may have to be licensed in certain trades, electric, plumbing, those sorts of things. But a general home improvement contract won't have to be. But if you have a municipality that may require that to be happening, make sure you check licenses. If you have an electrician come in to do your house, you need to have electrical work, they have to be licensed in the municipality. Make sure they have licenses. Another thing is we'll talk about the contracts themselves in a few minutes, but never pay the full price up front, that you're asking for problems when that occurs. It seems to be that in the fraud situations that I have been involved with, the contractor's incentive for finishing the job is in reverse proportion to how much they've been paid up front. If they have been paid everything up front, the incentive goes down. If they have been paid a little up front, the incentive has increased. And make sure you know what you have to pay and when those things have to be paid. All contracts have to be in writing. We'll talk about that in a minute. And if a contractor is not willing to put it in writing, run the other way. It's a violation of the law. So you need to make sure. Somebody can say, well, we'll just have an oral agreement. It can be a little bit cheaper if we do an oral agreement. Don't do it. Don't do it. It's against the law. It's against the law as it applies to home improvement contractors. The contractor is the one that's required to provide a written contract. Let's talk about a home improvement contract. What is it to begin with? We actually have in New York, under the general business law, it's Article 36A of the general business law, sections that deal with home improvement work. And so the first thing we need to do is define what is a home improvement job. Well, the definition of a home improvement is all-encompassing. It involves all types of things that you do at or around your house. So I think that you can assume in most instances it falls within the home improvement contractor law. It covers driveways. It covers landscaping. It covers swimming pools. It covers all types of things. A home improvement contractor is also defined under the law. And again, it's a really low standard to be a home improvement contractor. Excuse me. A home improvement contractor is one who does home improvements with the total price of all jobs in a one-year period of time is $1,500. Doesn't take much to hit $1,500 in the course of a year. It covers so anybody who does home improvement work totaling, that's all jobs, not just one job, but all jobs, total more than $1,500, you're a home improvement contractor. A home improvement contract is any work done by the contractor in excess of $500. I don't know about you, but anytime I've had somebody come over my house to do a quote-unquote home improvement job, it's always over $500. So it would fall within. So any home improvement contractor, anybody that does jobs totaling more than $1,500, and they come to your house and do a job that's more than $500, they have to follow the law. There are certain things it does not include, and it's cosmetic things, like somebody comes in and puts in drapes. That's not a home improvement contract. Or carpeting, that's not a home improvement contract. It doesn't include appliances. So if somebody, you buy a stove or a refrigerator and they come over and put it in, the home improvement law doesn't apply to that. It would include a custom home, which is a home that's built from scratch on land that's owned by the homeowner. So it's a home improvement contract if you have a piece of land and you go to a contractor and say, I want you to build a nice, beautiful house on my property, that would fall. They're required to follow the law there. It wouldn't apply to a situation where they have these things called spec houses, where the contractor owns the land and builds a house on that property and then sells the property to somebody else. But there are separate rules related to that. There are warranties that attach to that particular house that can last up to 6 years. So that's a whole separate issue. The first thing with a home improvement contract, that minimum threshold that we talked about before, one is all home improvement contracts must be in writing. Must be in writing. It's the law. There are heavy penalties associated to the home improvement contractor who does not comply with the law. Putting that aside, that it's part of the law, it just makes good sense. It makes good business sense from the contractor's point of view, and it makes good sense from the homeowner's perspective, put everything in writing so that everybody knows what is expected of each of the parties. It doesn't just protect the homeowner, it protects the contractor as well. What if you have a dispute over what work is included in the agreement? It's very easy to pull out the written agreement and the contractor can say, no, I wasn't supposed to do that. See, here's the things I was supposed to do. How many times can these disputes be resolved if there was a detailed contract? And when I say that, that also includes change orders. There are many times that a homeowner has a project being done and it's partly done and they say, it really would be nice to change this thing over here. Or put in this nice mantle over a fireplace or something. It doesn't hurt. The homeowner goes over to the contractor and contractor says, yeah, I can do that. What the contractor is saying, shows the miscommunication. What the contractor is saying is, yes, I can add that to the contract, and then at the end of the job, they give you a bill for an extra $500 to do that, and you will go, oh, I didn't realize that it was any more expensive. Whereas, and the homeowner is thinking when they say, hey, can you do that? And if the contractor doesn't say, yeah, I can do that for an additional $500, the homeowner thinks it's getting done for free. So how easy would it be for the contractor to say, yeah, we can do that. I'll give you a change order. And just write a separate piece of paper that says this is a modification of the contract. We're going to add a mantle over the fireplace, and it's going to be $560. And bring it to the homeowner, and the homeowner can sign it. Fine, we're good. Or bring it to the homeowner. The homeowner goes, whoa. I was just wondering if you could just kind of throw that thing in. I don't have an extra $560. And then it could get canceled, and then there's no problem. Everything's good. So get it in writing, get all change orders in writing. If you're a meticulous homeowner and you end up having 20 different changes to your job, have 20 different changes written down so that everybody knows who's responsible for what. If you're going to change, having a stairwell done and you're changing the spindles on the railing, you might not think it cost extra. Well, the contractor may have designed the project to have certain spindles, and that's included in the price. And you go for these fancy ornate ones, it may add a price to it. But the important thing is when the decision is made to make those changes, the additional cost is brought to the attention, and then the homeowner can make the decision whether or not to change it or not. So the first thing is it has to be in writing. The contract has to be in writing. Don't avoid that, and it's really good common sense. What has to be in the contract? Well, the contract must include the name, address, and phone number of the contractor. I can't tell you the number of contracts, I call them contracts loosely. It's the invoice that's been given to the homeowner after the job has been completed. Typically, it's that driveway paver that shows up and knocks on the door and says, hey, I have some extra blacktop in the back of my truck. I can give you a really good price for this. And at the end of the job, of course, it's 5 times what anybody ever expected or should have been charged for the job. And then it just has the name of a person at the top and a cell phone number. You have no way of contacting them after, and usually from out of the area. So you can never contact them afterwards. But it must have a name, it must have an address, physical address of the contractor, and a telephone number. The contract must also contain the dates when the work will be started and when it will be substantially completed. Contractors can estimate how long a particular job is going to take. And it can be what's the date that you expect to start on, and the date you approximate will be substantially completed. The that is required. It's got to be in the contract. So if you get a home improvement contractor who does this as a moonlighting job, they work somewhere else, and then as a side job, they do this home improvement types of things. And it's not expected that when they start the job, they're going to work 8 hours a day, 7 days a week until it's completed. That's fine, as long as it's in the contract. Started on May 15th, on or about May 15th, and completed August 15th. Well, that's a pretty long time to do a job. But if you know that, then fine. That's okay. I will tell you from my experience the problems that we have. A home improvement contractor in our area who does it as a side job kind of thing, never gave a contract to begin with, never gave a contract, never indicated when the job was going to be started. 2 months later, the job is still only half done. It was never the expectation of the homeowner that it would take that long. And then the contractor says, well, you know, I do this as a side job. I never expected to be able to do it this quickly. Put it in the contract. It's so easy. It's so simple. So that it has the dates when it's to be started, when it's to be substantially completed, and it should say whether or not time is of the essence, meaning those dates are firm or pretty firm. It should have in there what contingencies could change that, such as it may take longer to get that new custom-made window or something that is out of the contractor's control. The supplier may have some reason, or you may have weather issues. We may get into you estimate that it'll take 7 days starting May 15th, be done May 22nd, 1 week job, but it rained the entire week. Well, nobody can expect someone to be doing that particular job while it's raining the entire time. So those types of things could extend the time for completion, but it doesn't mean it extends it to September. The contract will set forth the expectation of the parties. When are you going to start this thing? When are you going to be finished? Another thing that obviously it should include a description of the work that is being done, including if there's any particular materials that need to be, special ordered or things like that. That should also be included in the contract. Also, the law requires that there must be a notice in the home improvement contract of a possible lien law situation. In other words, a mechanic's lien. It should say in there that if the contractor is not paid, he may file a mechanic's lien against your property to ensure that he will be paid for the work that he has done. If he does not include that provision in the contract, it's a violation of the home improvement contract law. Many projects are longer and go through various stages of completion. Maybe it's a job where you're adding a porch onto the house, and it may take a few weeks to get finished, and the contractor may need to pay employees or pay for supplies over that period of time. So frequently, they'll have a thing called a draw schedule in the contract, which means at a certain point of completion, X number of dollars is owed. And then another stage of completion, X dollars more are owed until the job is finally completed, and then the final payment is due for the total contract price of, say, $25,000. One thing we talked about when I first started talking is don't get, if it's a project that's going to be done in segments, don't pay a large percentage up front. One, contractors many times have credit with their supply house. So they don't necessarily need all the money to pay for all the supplies up front because they don't owe anything to the supply house for 30 days or whatever. However, a modest payment up front may be appropriate. Maybe the contractor has employees and has to pay them weekly, and needs some of the money up front. But, a 10% up front is not unreasonable, but 50% up front is kind of unreasonable. So figure out what that draw schedule is, and that the contractor is only entitled to receive those payments when he or she has completed that particular stage of the work. It may be that another 10% gets paid when the job's 25% complete. Fine. Work that out ahead of time so that you know. And then the contractor, if they come back to you and say, look, I need half the money now. Say, well, our draw schedule says that you're not entitled to that until this stage of completion. You are well within your rights to say, I'm not going to pay you that amount until you get to that stage of completion. Also, a home improvement contract must have a 3 business day right to cancel in the contract. The homeowner has, this is one of the rare circumstances, I can emphasize, rare circumstances where the consumer has 3 business days to cancel. Not every contract, every consumer transaction, people have 3 business days to cancel. It's only in certain circumstances. This is one of them. You have consumers 3 business days to cancel from the time that you enter into the contract. The notice that you have 3 business days to cancel should be in the contract itself. And those 3 business days begin to run at the time the parties enter the contract. The job may not start for a week, but you have 3 days after you sign that contract to change your mind and cancel. And it should be in the contract. I give this to home improvement contractors. Be very careful and make sure that's in your contract. Because if it's not, the 3 days never starts to run. So you could go through the entire contract, do all the work. If you haven't given the landowner the 3 business days to cancel, as soon as the job is done, they can cancel. And then where are you? You've done all this work, and the homeowner canceled the contract. Then you have a big fight going on as to how much you should be paid. But the fact remains is the homeowner has the right to cancel that contract. And you could be out of luck. So, home improvement contractors, make sure in your contracts you give the homeowner the 3 business days to cancel. It is also in everyone's best interest, the contractor most importantly, that if they wait the 3 days before they start doing any work, then they avoid that whole situation where a homeowner would cancel after some of the work has already been done. So it's a requirement. Make sure it's in there. And that's what's required to be in the contract. Again, I think it makes sense to, if something gets changed from that original contract, put it in writing. Make sure that the change is in there. And then everybody knows. Then we don't have any problems going along. Another thing is money that's paid. There is provisions in New York's lien law that says any funds received for work to be performed later are considered to be trust funds. In other words, the contractor who's paid in advance must hold those funds in trust for the faithful completion of the job. If the contractor, and we've had this situation happen before, is using one homeowner's deposit to help pay for the job that he's finishing up later on, he's finishing another job before he starts the homeowner's job. If he uses the funds from the new homeowner's job to pay for the old job, that is a violation of law and it is a crime. You cannot use trust funds for anything other than what you were paid for it. So be aware, contractors, if you're using money from the new job to help finish up paying for the old job, you are committing, in some instances, a felony. So the money is to be kept separate. What the contractor is required to do is to put advanced payment of funds in a separate account that is just holding the trust funds. If you have about 3 jobs going at the same time, you can put them all in one account as long as you keep records of whose money is in that account. If you don't keep records, you are presumed to have violated the trust fund provisions, and it could be a crime. So all that money must go into a separate account, separate from a general account that the contractor has, a separate trust fund account. It's very simple. I've had contractors come to me, but how do I do that? I mean, my bank is, you go to your bank and you open up a separate account, just a separate account, that the only money you put in that account are the deposits or advanced payments that homeowners make. Then, when you buy supplies for that job, you pull money out of the trust account and put it in your general account. You keep the two completely separate. If you start monkeying around with the money and not be able to account for it for that particular job, it can be a crime. So you don't want to do that. So any funds received for work performed later are trust funds. They must be treated as the money of the homeowner until it has been earned by the contractor. Contractors, it is not your money. It is not your money until it's been used. You cannot commingle that money with your other general account. Just open a trust fund, a trust account. Just open a separate account in a bank and just put the money in there and keep a record of whose money goes in there. And when you pull money out of it, put records, do the records and say, $1,000 to pay XYZ supply company for lumber or whatever it is, okay? Only withdraw the funds according to the draw schedule that you have, and it is a protection for the homeowner, and it's also a protection for subcontractors. In case you hire somebody else to come in and do the plumbing and things, those funds can be used for that. So any funds received in advance must go in escrow. It must be deposited in that trust account within 5 days of receipt, and it must be in a bank or institution that has a branch in New York. It, again, remains the property of the homeowner, and unless it's in the contract, and it's just very easy to put it in the contract, where your trust account is, unless it's in the contract by the bank name, it must, unless it's in the contract, you must give the name of the bank to the homeowner within 10 days of the deposit. So it's just as easy to just put it in just put it in your contract where you have your trust account. The contractor has the trust account. Keep records, and again, if you don't have records, it's deemed that the funds were mishandled, and you don't want that. Again, you can only withdraw from that trust account the amount of money that was deposited by that particular homeowner. If you are, let's say you get a contractor gets a deposit of $10,000 to do a home improvement contract, but ends up withdrawing $11,000 out of the account, that's a no-brainer. He's mishandled the funds because he's using somebody else's money, obviously, to pay for this particular job. You can't withdraw more than what the customer has already given you, or you're using somebody else's money. So you can't withdraw in excess. Again, failure to deposit these payments in advance is a violation of law. As far as the home improvement, that was the lien law, and that can be a crime. The home improvement contractor law, that has to be in writing. You have to have the day that when it'll be the name, address, telephone number of the contractor, the day when the work is to be started, and when it's supposed to be substantially completed. If you do not do this, contractors, fines can be up to $2,500 per violation. Just a technical violation of the home improvement contract law is a $100 fine. It can be even more significant after that. Not to mention that you could run into a proceeding brought by our office. I have many home improvement contractor cases that I'm working on because people are acting in violation of the home improvement contractor law. So avoid all that. Some prime areas for scam artists in the home improvement realm is asking for significant down payments or significant advance payments. Negotiate a schedule that's based on completion, and the best advice that I can give to a homeowner is the homeowner should always be ahead. Meaning, if there is a draw where 50% of the work is completed, don't have anything more than 50% in payments made. It's probably better to have only 40% of payments made when 50% of the work is completed. Know what you want done. Don't be talked into something that you cannot afford. Make sure that you get references. Make sure that you get all guarantees in writing. Oh, yeah, we can do that. Well, put it in writing. There have been different, efforts put forth to try and have a statewide home improvement contractor registration program. That's been talked about for many, many years, and it's never come about. It's very unlikely, I think, to happen at this particular stage. So the home improvement contractor licensing is usually a municipality-wide. Typically downstate, it's county-wide, or in New York City, it's down in New York City. If someone ever has a problem with a home improvement issue, they can feel free to contact my office. Our office offers a mediation program whereby we will attempt to mediate the complaint with the contractor to see if it can get resolved in some fashion. If it cannot, the homeowner may be stuck having to go and sue the contractor, either in small claims court if the claim is small enough, or may have to engage an attorney and sue them directly in Supreme Court for larger type things. But we can attempt to try and mediate it, resolve it. If we're unable to, then the homeowner may have to go out and get their own attorney. If home improvement contractors, if there's a repeated and persistent violation of the home improvement contractor law, our office does have jurisdiction to sue the contractor for repeated and persistent illegality. To avoid all that, make sure that you comply with the home improvement contract law. If you don't know what it is, find out about it. Contact your local Builders and Remodelers Association. Contact maybe other contractors in the area, more long-term, bigger contractors who will be aware of this, and get the information. Because if you don't, you could face significant penalties and fines if you don't. If anybody has any questions regarding the home improvement contracts, I'd be glad to answer them. Otherwise, thank you all for joining us here at Cornell Cooperative Extension for our monthly consumer issue program. We invite all of you to come down and join us. It's always great when we get a nice crowd. I'm going to hand it back to Kenneth to wrap it up, and he'll inform you as to how often we're here and when we're here and when you can join us. So thank you. Kenneth.
All right, thank you, Mike. I'd like to thank everybody for coming down here to Cornell Cooperative Extensions of Tompkins County and being with us, and Michael, for this talk. We do it every second Thursday of the month. We welcome everybody. need to come down and be with us, we're also going to open it up so you can email questions to KEM228@cornell.edu. You could also call our consumer helpline here at CCE Tompkins and leave questions, and we'll have Mike answer them for you the next time he's here next month. Thank you very much, and have a good evening.